request you all to please be seated and put your phones on silent. We will begin with the program in next 5 minutes. Thank you.
अभी दिखा रहा था अच्छा स्पीड तो ठीक है नहीं मैं तो लेन वायर लगा क्यों आ रहा है हेल्दी है ना नहीं कैमरा बंद नहीं कैमरा मतलब चलेगा ना ठीक है लाइन पे रहना ठीक है मैडम मैं जब भी आप बोल रहे हैं जैसे कि मैं करूँगा ना उठा लेना खड़ा ठीक है
Good evening, one and all. I, on behalf of EBC, feel deeply honored to welcome you all on this momentous occasion where we gather to release Constitutionalism and the Rule of Law in a Theatre of Democracy by Justice A.K. Sikri. To mark the occasion, I would first like to welcome the dignitaries on the dais. People do not decide to become extraordinary. They decide to accomplish extraordinary things. Our chief guest today, Justice Sanjay Kaul, is the perfect epitome of this. His illustrious career spanning over 4 decades as a lawyer and a judge has been marked by a steadfast commitment to justice. As a judge at Supreme Court of India and the Executive Chairman of the National Legal Services Ms. Bhumika Indulia, Associate Editor EBC, to felicitate Justice Kaul. A good judge is not someone who is always right, but someone who is fair, impartial, and willing to listen to all sides of an argument before making a decision. Justice Sanjiv Khanna is a prime example of such a judge. Coming from a family of legal academics and scholars, Justice Khanna's 2 decades-long experience as a practitioner at the Delhi High Court and subsequent elevation as a judge at the Delhi High Court in 2005 and at the Supreme Court in 2019 attest to his unwavering dedication to the field. We are honored to have you here with us, sir. I would like to request Ms. Kriti Kumar, Editor, EBC, to felicitate Justice Khanna. Caroline Kennedy once said, "Lawyers are the foot soldiers of our Constitution. When rights are violated, they are the ones who are at the forefront of protecting them." This statement perfectly holds true for Mr. R. Venkataramani, the distinguished Attorney General for India. With 42 years of experience in mastering various legal disciplines such as constitutional law, human rights law, civil and criminal law, etc., he has proven himself to be a stalwart defender of justice and individual rights. We feel privileged to have your presence amongst us, sir. I would like to request Ms. Apurva Goyal, Editor EBC, to felicitate Mr. Venkataramani. We are immensely delighted to have Justice Satish Chand Sharma amongst us today. As a trailblazing first-generation lawyer who has now ascended to the position of the Chief Justice of the Delhi High Court, Justice Sharma is not just shattering barriers, but also paving noble pathways for future generations. It is an honor to have you here with us, sir. I would like to request Shrajan Agarwal, Brand Marketing EPC Learning, to felicitate Justice Sharma. Justice R.F. Nariman commenced his legal journey in 1979 as an advocate and achieved the distinguished title of Senior Advocate by the Supreme Court of India at a remarkably young age of 37. With an extensive experience of 3 decades in the legal profession, Justice Nariman has an impressive record of 500 reported judgments as an advocate and 360 judgments as a judge. Although Justice Nariman may have retired from judgeship, his enlightening YouTube channel continues to be cherished by all. We are delighted to have you here with us today. I would like to request Vidhi Khurana, Editor EBC, to felicitate Justice Nariman. The true essence of teaching lies in the teacher, not the classroom. And Padma Shri Professor Upendra Baxi is a shining example of a teacher who has gone above and beyond to make a difference in the lives of his students at various universities across the world. His exceptional contributions to various areas of law, including human rights and constitutional law, are truly remarkable and have earned him numerous accolades, including the prestigious Padma Shri Award and the Emeritus title conferred upon him by the University of Warwick. It is with great honor that we welcome you here today, sir. I would like to request Deeksha Dabas, Legal Editor, EBC, to felicitate Professor Baxi. It is with great honor that we now introduce the man of the moment, Justice A.K. Sikri. With over 4,700 With over 4,700 reported judgments across various legal domains and numerous articles and publications, Justice Sikri's contribution to the field of law are widely recognized. His famous quote, "While the human in law is important, humane in law is indispensable," reflects his humane approach to the law, which is evident in his latest book. Justice Sikri, thank you for writing this book that is sure to inspire Bhumika Kumar, Legal Content Marketing Associate, EBC Learning, to felicitate Justice Sikri. In the 1940s, two young brothers ventured into the world of law book selling and publishing, unaware that they were laying the foundation for what would become India's largest legal publishing house. Today, the third generation is proudly carrying forward this legacy. Mr. Sumit Malik, with his visionary leadership as the director of EBC and associate editor at SEC, has propelled it to new heights. Mr. Malik is also the head of finance chair at the Entrepreneurs Organization Uttar Pradesh, demonstrating his versatility and commitment to excellence. I would like to request Balram Pandey, Law Clerk to Justice Sikri, to felicitate Mr. Malik. It is also gratifying to have with us in the audience Honorable Sitting Judges of the Supreme Court of India, Justice Hima Kohli, Justice M.M. Sundaresh, Justice Ehsanuddin Amanullah, Justice Manoj Mishra, Justice K.V. Vishwanathan, Justice Ujjal Khoyan, former Chief Justices of India, Justice Uday Umesh Lalit and Justice R.M. Lodha, Honorable Sitting Judges of Delhi High Court, Honorable Sitting Judicial Members of NCLAT and NHRC, and esteemed former Supreme Court and High Court judges. A warm welcome to all of them and to all our guests. Thank you for being here with us today. I would now like to invite Mr. Sumit Malik, Director EBC, to deliver his welcome address.
My Lord Justice Sanjiv Kaul, my Lord Justice Sanjiv Khanna, my Lord Justice Nariman, Mr Venkataramani, Attorney General, Professor Upendra Baxi, Senior Advocates Mr Arvind Datar and Madhavi Goradia Divan, Professor C. Raj Kumar, Justice Sikri, our author, Honorable Judges of the Supreme Court, sitting and former, Honorable Judges of the High Court, sitting and former, Professors, students and gentle people. Thank you, Professor Baxi, for this beautiful phrase. It is my privilege and pleasure to welcome all of you to this event where we will be celebrating the release of Justice Sikri's Constitutionalism and the Rule of Law. It is also my privilege to welcome Justice Sikri to the pantheon of EBC authors. I am grateful to our chief guests, our guests of honor, and our panelists for taking the time out to participate in this event. I begin today's address where I had left off from an earlier welcome address, at a book launch, where Justice Sikri was the chief guest. I had mentioned that Justice Sikri and I have some very interesting conversations around him writing on some unexplored areas of law and some perspectives of law hereto unexplored. This is probably the first of many such gems that will flow from his computer. He has presided over many EBC book releases, and here we are today at the book release of his book, which is divided into 4 parts and has 22 essays. In this world of technology and artificial intelligence, which allows for instant self-publishing on blogs, etc., the question is, how do we at EBC see ourselves? What is the role of a publisher? In today's context, I can say that we see ourselves as trustees of legacy of authors. We have over the years continued to preserve the legacy of our authors, names that are synonymous with the study, teaching and practice of law. Professor V.M. Shukla, Professor Kaul, Dr. Singh, Professor Ahmed Siddiqui, Sri V.D. Mahajan, Sri V.D. Ramachandran, Professor T.K. Tope, Professor V.M. Gandhi and others. And their books are being revised at regular intervals. Professor Baxi and Ms. Divan are EBC authors, and I hope that Mr. Datar will accord us this privilege soon. A book, as I see it, is a custodian of thoughts and ideas. Whereas judges, when deciding cases, are bound to decide the list before them on a given set of facts and apply the law to those facts. Authors, when writing books, do not face such limitations. A good author will explain the law to their audience, but a great author will also show the light forward by placing their thoughts and ideas in a book of what they consider the law ought to be. Justice Sikri has done exactly that in each of the chapters of his book. And we will be witness to a very interesting panel discussion on constitutionalism and rule of law later on in this program. We at EDC, as we enter our 81st year of since our incorporation, and what we have sort of learned to understand is what the academic and legal profession requires and what our role can be in fulfilling that requirement. We believe that our role is to bridge the gap between legal information and knowledge and those who consume that legal information and knowledge. As a third generation of this publishing house, I have been blessed to have been shown the way by my elders. My great-granduncle and grandfather had very humble beginnings, serving lawyers, including the great Mr. Ambedkar, when they started off in 1942. But even then, the mission was clear: provide a service, assist the practitioner in their work. The mission continued with the same spirit when EBC started publishing books for lawyers and for students in 1947. The books that we produce must necessarily be of very high quality and assist the reader in their quest for legal knowledge. In 1969, Mr. Swain Malik graduated from Delhi University. Having studied by the newly introduced case method, we realized that there was a need for faster reporting of Supreme Court judgments. Thus came about the innovation of Supreme Court cases. As all of us are aware that there can be no second edition of a law report, and it must be got right the first time. Prompt, accurate and complete reporting has been our philosophy, which we've adhered to since then, and we understand and recognize our responsibility more so that the honorable judges on the bar rely on ICC. We have now taken up the onerous task of reporting judgments of the Supreme Court since 1950 to 1968, a period not covered in SEC earlier. Just in the first 10 volumes we discovered and reported many judgments of the court hereto never reported before. EBC was one of the first Indian publishers to introduce a legal research database on CD-ROM in 1996, which was less than 650 MB in size then, and now the SEC Online Web Edition has grown to over 20 terabytes of data, 5 million documents covering over 400 plus jurisdictions around the world. Even though we believe that the printed book is not going away, yet for the tech savvy, we have the EBC's EBC Reader platform, which is ready and has over 400 books, and we add new books to it every day. The SEC Online blog, on which we report happenings in court, law schools and the like, no live reporting, has now over 1 million views and over 500,000 visitors every month. Constantly, innovating EBC's newest services, EBC Learning, an e-learning platform, and Mercury, a judgment tracking software, are already gaining loyal users. We are also fortunate to have as part of the EBC family a dedicated team of legal editors, software engineers, DTP staff, copy editors, sales and marketing staff, and managers who are as much, if not sometimes more, invested in ensuring that what we produce from the House of EBC is of high quality, authentic, accurate, and reliable. It has been a wonderful experience working with Justice Sikri on his book, and we've already discussed more works which are in the pipeline. Thank you so much.
Thank you, Sumit sir. I would also like to extend a warm welcome to Justice Sanjay Kaul, Judge, Supreme Court of India. I would now like to request the chief guest for today, Justice Kaul, to address the audience.
Justice Khanna, Justice Sikri, Justice Venkataramani, Attorney General, Chief Justice of Delhi High Court, Professor Upendra, Baxi, Mr. Malik, large number of sitting and retired judges, members of the bar, ladies and gentlemen. To see such a galaxy of luminaries around me is a matter of great satisfaction and a reflection of Justice Sikri's popularity and his legal eminence. I've had the privilege of practicing as a lawyer before many of the honorable judges here, being with some of them part of the bench, and so it's a momentous occasion for me also to be here and have the opportunity to introduce what Justice Sikri is written upon. Justice Sikri has always been an academician first, and thereafter a man of law for other reasons. His judgments reflect his academic interests. Many of the judges have also had the privilege of being taught by him. I didn't have that, I passed out earlier than that. Since Justice Sikri mentioned that he would be writing this book, I was eagerly looking forward to it. And it is my great honor to be here, invited as a chief guest. In addition to being a celebration of Justice Sikri's judicial career, the book is an important contribution to the constitutional scholarship. It covers a range of themes from the principles governing judicial review and the development of right-based jurisprudence to justice delivery, and serve as a useful guide for comparative constitutional studies. The book already carries a fitting forward by Chief Justice Sanjay and an introduction by Professor Upendra Baxi, whose life work includes the study of Indian constitutionalism. It also carries an afterforward by Justice Nariman, whose understanding and of commitment to constitutional values is reflected in cases such as Navtej Singh Johar and Shaira Banu. Having received their adulation, and not much remains for me to say, apart from wholeheartedly endorsing their views. I've also had the privilege of sitting with Justice Nariman for almost more than 3 months, which was cut short in the middle somehow. Professor Baxi, who is in the audience today, famously theorized the constitutionalism is one of the 3 constitutes of the Constitution, the other 2 being the text and interpretation of the text. Building on Professor Baxi's insight, one conception that has been construed over the years is that Constitution contains answers to all aspects of Indian life, or what contemporary scholars have described as constitutionalization. I would like to add a few words on this phenomena, which can often go underlooked, especially in the humdrums of the Supreme Court's daily work. The starting point is the distinction between constitutionalism and constitutionalization. While the constituents of constitutionalism are often contested, some elements remain consistent. Among these are judicial independence, judicial review, and the entrenchment of some constitutional provisions. These themes are richly detailed in Justice Sikri's book. In India too, the basic structure doctrine has been regarded as the strongest evidence of Indian constitutionalism. One concern in a democracy is the subaltern, marginalized groups who have been subordinated by dominant classes. While the text of the Constitution guarantees right of subaltern constitutionalism, has been given the subaltern a platform to realize their rights. We have all read and been inspired by Professor Upendra Baxi's seminal pieces, Taking Suffering Seriously, in which he described how the social action litigation transformed the Supreme Court to finally come of age and become a court for the Indians. To me, the value of social action litigation extends well beyond the outcome. For example, the participation of subaltern in the process of litigation has contributed to the development of an alternative vision to the Constitution. This is significant as their voices are often silenced or erased from the democratic polities. Constitutional litigation has provided these subaltern voices a space to negotiate, with dominant elites as the court process compels the state to respond to their claims or at least, very least, defend policies. Take the case of Tukaram versus State of Maharashtra, which was based on a rape complaint filed by the victim, Mathura, who was from the Adivasi community. While the decision did not do justice by the victim, the case became a part of the public consciousness. Protests and public meetings were held in different parts of the country, and many women groups were mobilized calling for both the reopening of the case by the Supreme Court and for reforms in the criminal law. Owing to the pressure, the government at the time asked the Law Commission to study the law on rape, which led to significant legislative reforms. While this case did not see success in Supreme Court, it sparked a nationwide movement that had grown and taken form of its own over the years. Constitutionalization has been used to describe the practice by which constitutional courts have been reviewing contentious social and political questions. The phenomena is common to both new and well-established constitutional regimes. In some ways, constitutionalization is a subset of what constitutional regimes. Professor Ryan Hershey describes as the transfer of power from representative institutions to judiciaries. I have always said that the judiciary should not intervene just because it disagrees with the government policy or the quality of governance. Yet we see many examples of this in India. According to Anuj Pujwania, courts have come up with several innovations such as diluting the rule of locus standi and procedures to take on governance role. This has perpetuated an image of the higher judiciary being a panacea for various social and problems that plague India. But what if it is not so? The danger of relying on adjudicatory means for settling fundamental morals and political controversies is that the courts turn into political decision-making bodies. This is a serious concern on several levels. First, and very obviously, it disregards the fundamental principle of separation of powers. Second, judges are not equipped to decide these questions. In fact, several of these questions are given constitutional color are not capable of judicial resolution. The only solution then is for courts to issue directions and oversee the process of resolution. However, courts rarely limit their role to oversight, and there is always a risk of going beyond this role. Third, approaching court to direct and design policy changes may insulate substantive policy making from democratic politics. In the long run, this can have irreversible consequences, such as fracturing the democratic fabric of the country. This begs the question, is there an alternative approach constitutional courts to decide contested moral and political questions? There are some contemporary examples of this. In Ireland, a predominantly Catholic country, the 8th Amendment to the Constitution of Ireland granted equal rights to mother and unborn child. This meant an almost complete ban on abortion. In 1992, the Supreme Court of Ireland allowed an abortion of a 14-year-old rape victim on the basis that she was suicidal. Yet, the Supreme Court ruling did not make it legislation. Then we heard of Savita Halappanavar, a 31-year-old Indian origin woman, who was 17 weeks pregnant when she was denied an abortion that resulted in her death. Her death reignited the campaign to amend the Irish constitution and legalize abortion. Eventually, in 2018, a referendum repealing the 8th Amendment was held, where the Irish people voted to remove the 8th Amendment with an overwhelming majority of 66% to 34%. Although approaching the Constitutional Court remained an option, it was public reason that persevered. It now stands out as an inspiring instance where contested ethical questions were decided by public themselves and without any judicial intervention. Another example of choosing to not subject every aspect of social life to the lens of judicial or institutional recourse is the Me Too movement, which gathered momentum a few years ago. It was a time when numerous accounts of sexual harassment were shared on social media to raise awareness about how common sexual harassment is. Those who were called out were almost always persons who occupied a position of power or influence over the victim. An employer, a teacher, or a senior in college. It also included institutions who were called out for enabling abuse or for refusing to accountability when they were made aware of it. A common critique to Me Too movement was, why have the victims now filed a complaint and chosen instead to name and shame on social platforms? And here lies the movement's uniqueness. On one hand, it signaled a rejection of the law for being ineffective in redressing claims of sexual harassment, while on the other hand, it was an active choice not limited redressal to a legal standards and remedies. For example, the law provides for incarceration if the accused is to be found guilty. This often does not address the victim's needs. The Me Too movement was a watershed moment in the sense that it enabled accountability, reconciliation, and peacemaking with the perpetrators through the means of public apologies and acknowledgements. It prioritized, without any judicial intervention, restorative justice response to sexual harassment by bringing together victims and responsible parties. Therefore, a broad point which I wish to make is that we must encourage a cultural examining social and political problems critically, instead of viewing them as problems that will ultimately end up before a constitutional court. The solutions arrived at are often more equitable and enduring. Of course, as long as these social and political questions continue to be referred to constitutional courts, the approach that Justice Sikri suggests in his book of following a balanced approach that tends neither towards activism nor self-restraint is the best approach. I began with the analogy to the yew tree immortalized by Wordsworth in his poems. Through this book, Justice Sikri's ideas will remain timeless, with this book serving as a lodestar for generations that never had the opportunity that we, as contemporaries, have had. I hope this book is only the first of the many. Thank you, Jay.
Thank you, sir, for your enlightening words. I would now like to request Justice Nariman to address the audience.
My dear Arjun, Sanjay, Sanjeev, Venkataramani, Chief Justice Sharma, Professor Baxi, Mr. Malik, dignitaries, brethren, ladies and gentlemen. This beautiful book has come as a timely reminder to democratic governments worldwide not to tamper with constitutional values. You have all seen what has been happening in Israel at present. Israel has, despite this huge demonstration by so many of its people, bludgeoned through a law in the Knesset, in which it has cut at the root of constitutional democracy. It has done three things. One, it has tampered with the appointment process of judges. Two, it has tampered with judicial review. And three, it has tampered with how you judge legislation. In short, the balancing act that judges perform, stating that a legislation is either reasonable or unreasonable. Israel and India started out pretty much at the same time. They started out in 1948, we in 1947. The difference is that they had a constituent assembly which somehow just abdicated in favor of stating that the Knesset, which is their parliament, will by simple majority and from time to time make what they call basic laws. Whereas we have this beautiful constitution, which is the longest in the world. So Israel is therefore without a written constitution. And look at the consequence. Basic law after basic law has been made. There are 13 such made till date. One of them in 1984 was a basic law with the judiciary. And apart from setting up an independent judiciary, it had a judicial appointments commission in which 5 to 4 it was tilted in favor of the judiciary. There are 3 members of the judiciary, you had 2 from the bar, and on the other side you had 2 ministers and 2 MPs from the Knesset, which resulted in persons like Barak being appointed president of the tribunal, a man who Justice Sikri admires and whose name will be throughout the pages of this book. And it is this great president who laid down judicial review as a matter of Israeli doctrine in 1995 in that famous Bank of Israel case. Now, despite all this having been done, the appointments process now by the new law is sought to be weighed or weighted greatly in favor of government. In India, fortunately, we have had 4 judges' cases, all of them of large benches, first of 7 and the next 3 of 9. And the upshot of all these judgments ultimately is that we have wrested from the executive the right to appoint our own judges and have jealously guarded it by ultimately even striking down a constitutional amendment. Unfortunately, in Israel, today this is not the case. And the idea obviously is that the appointments process is now in the hands of a right-wing government, which will now appoint judges only favorable to its policies. The second change they have made is also something that has been tried here before. The change made in Israel is that only 15 judges sitting en banc now, instead of in divisions, can judge the constitutional validity of a law. And if it chooses to strike down such law, 80% of them will have to agree. If you remember, one of the many features of the 42nd Amendment was exactly this, that 7 judges here of the Supreme Court and 5 judges in the High Court would be the minimum number to decide constitutional validity of central and state statutes respectively. There was a bifurcation. And 2/3 majority was required in both. Now this failed here because the very next constitutional amendment, the 43rd, undid these 2 provisions. They were contained in Article 144 capital A, which was abolished, and in 228A, which was also abolished. One other disturbing feature is that in Israel, assuming that you have crossed the threshold of 80%, the Knesset by simple majority can now annul your judgment. Now even that has been tried here and has failed. The great Sambamurti case, if you remember, in Article 371 capital D, dealing with Andhra Pradesh, you had a subclause 5 which said that a party to the litigation, that is the state government, between government servants and the state, may choose to enforce an award, may choose to modify it, may choose to annul it. Our court struck it down on the ground of basic structure, saying obviously this is a huge interference with the basic tenet of separations of powers, and it's the judiciary alone that can decide and enforce its decrees and judgments. So this has been tried here and has failed. And so far as the last is concerned, reasonableness, strangely, our Article 19(2), which dealt with restrictions on freedom of speech, contained an omission as to whether restrictions should or should not be reasonable. This was immediately rectified by us in our first amendment. So reasonable was added. Whereas here now what they are seeking to do is to take it away. The people in Israel should be given a copy of this book, because this book will show them our way of having dealt with each and every transgression that has been made. Thank you all very much.
Thank you for those wonderful words, sir. I would now like to request Mr. Venkataramani to address the audience.
To address a power-packed audience, I think I require a lot of humility, and I suppose I'll be able to gather it in the course of a few minutes of my very confined engagement. I mean, to this book, when it landed on my table, I was wondering when I was going to complete reading this book. But I proved myself false, that within 24 hours, this book landing on the table, I almost finished reading this book, because the absorption content of the book, I confine myself to only one concept which I think may float around for some more time around us. If Montesquieu has to be here today, probably he would fundamentally rewrite his book. And if the grammar of politics has to be rewritten today, we would be probably looking at the whole world of political process, lawmaking process, institutions involved in this, and the rules of regulation concerning these institutions in fundamentally different ways. And when I wrote a book on disciplinary judgments for the first time, I was exposed to an idea of a new theory of courts, where courts become deliberative institutions. They're not merely institutions which are to receive and to respond. So we need a new theory of courts where, in the expanding horizon of fundamental changes in life around the world, domestically and globally, this book brings a very interesting insights. When I say the new theory of courts, I must digress here for a minute. When that philosopher, American philosopher Alfred North Whitehead, thought of the world as an idea and a process, and you compare it with it and bring it in the realm of lawmaking today in contemporary societies, and coupled with the more fundamental thing that's happening. When Karl Marx said in his Communist Manifesto, philosophers are only either to interpret the world, but the point how it is to change it. Who is the agent of change? What kind of institutional processes? And what responsibilities, obligations, duties, powers? How do you spread regulatory understanding on all this? So you are seeing globally now the driving power of changing the world as headed different trajectories. Russia, China, and the new emerging democracies in Eastern Europe. So there is a new unfolding development across the globe where the relationship between institutions of law, I call it in the larger sense, institutions of law and justice, legislative, executive, judiciary, we have a very conservative understanding, very traditional way of looking at it. But the lines become very blurred. But just Kaul talked about the importance of maintaining certain lines. I think today we are moving the lines sometimes here, sometimes there, but depending upon a certain trajectory and persuasions which enter the court process. Will it be possible to have them brought within a concept, a rule, a regulation, an understanding? I think it's going to be very difficult. But we need to move in that direction. And all the important insights which we gather every day from the Constitutional Court's work, I think gathered in this book. And that's a great contribution which I think one can probably talk about the book. And the spread of the chapters, when you just pick up the contents of the Universal Declaration of Human Rights or all those later day conventions and covenants, you can all condense them and put them together in this book and see them here. When Vishaka was on the part of our jurisprudence, we were sitting back and wondering what exactly is this new entry into jurisprudence. But it has become the mainstream of our understanding of law and justice. And how did it happen? I think it must happen more and more. If the attorney doesn't speak like that, I may be, of course, very conventional conservative. If the attorney speaks a little more, I can be radical. But I think the line somewhere lies between this. Even I will probably talk about the understanding of conventionalism, radicalism, etc. I think outdated. Because the way global changes are taking place, global institutional motions are moving towards unknown areas. I think we need to welcome ideas which are contained in the book more and more. And every endeavor, every effort, every human mind's engagement in writing more and more about these ideas, I think are going to be part of a life and a common engagement towards justice. With these few very humble thoughts, I close my address today, and I'm sure that this book will not merely traveling around the Indian shores, but across the globe. I wish you all the best, Justice Sikri.
Thank you for your enlightening words, sir. I would now like to request Professor Baxi to address the audience.
And Mr. Justice across all, the Chief Justice, distinguished members of the bar, very many distinguished friends and participants whom I see in the up to the middle of the room, of the hall. So Malik and Sumit Malik and dear friends, it's very nice to be here and to hear so many learned speeches by people who know better than I would ever know. Therefore, I'm in the business of taking huge notes. And I have this habit of, taking notes ever since Murli is there, and I would know. It was my teacher to the Government Law College in Bombay. So it's a pleasure indeed to have him here. And it is very nice to be talking with you all this evening. I entirely agree with Justice Nariman's standpoint that this book should travel to people of Israel. And I think it should be translated both in Hebrew and Arabic. Moreover, I think it's on the agenda of Sumit and Surendra now. Because Justice Sikri refers to Barak very often in his book, and is a strong humanity of constitutional judicial view as he expounded it, and rule of law as Barak expounded it. He tested limits as we did on basic structure. The justices, learned justices tested the limits not of their own power, not of the executive power, not of legislative power. It's very, very vast indeed, compared to what judicial power wrestles with. Judicial power only imposes reasonable limits on executive and administrative powers. That's all it does. But the propaganda is so heavy. So I don't know what Israel can return by way of a gift to us. Maybe we think about that sometime. I think, before I come to the notes that I've made, but I think London Attorney General was quite right in saying that we need some redo of grammar of politics or some theory of course, I think you said. And the globalization, hyper-globalization, headlong and headless globalization that we see now all over the world, plus this specter of war as a solvent of basic problems that people have. Regime change, as in Syria and Iraq and other places, Libya. The world does not wait for theories to arrive. And therefore, are we wrong in seeking with good old liberal values, constitutional values, or should we look around? It's a big question. I don't know the answer to it. I personally consider the search itself is dangerous. Venkataramani, I have to say this to you. The search of adjusting theory of law to changing circumstances, global circumstances, is itself a moral mistake. That's what basic structure teaches me is. There are certain values by which we must go by, as a nation, as a society, as a state. No matter what happens elsewhere, 60% of Republican Americans belonging to the Republican Party think that the elections were stolen in 2020 by Joe Biden. And there is a very real possibility that Mr. Trump will be seen again in the White House in the near future. And the first act he will do is to sign off an amnesty or immunity to himself for all the trials that are going on in the court. And what he will do in the 4 years is dreadfully imaginable. So things are bad in Russia and in China. And I think India has managed a theory of judicial process that we ought to study more deeply. I don't fully agree with the idea that judges appoint judges is the innovation made by the Supreme Court of India. Before the Justice Sanjiv was here, he had been a party with judgment written for the court by Justice Keir, and he is himself a learned opinion on himself, and so is Justice Korean, but he has changed his views afterwards, after retirement. Now that's very puzzling thought. When judges receiving superannuation for services rendered in the past change their mind, only judgment they were given, what significance may be attached to them? Chief Justice Sanjay also apologized to the nation for habeas corpus case while he was Chief Justice. And he was in the habit of giving many apologies. I told Mr. Chief Justice Sanjiv, asked him upon retirement, I in fact wrote an article that he doesn't deserve to get a pension because 3 times he apologized and told the nation that he was wrong. And he was applauded by the nation when he said he was wrong. He did terribly wrong, then he said in civil service cases and so on. He said in 3 cases he was wrong. So I think there is a lot of, to digress better, a lot of things that should, and I know Justice Rocker does not always agree with me, but I think there is a problem here. Can a judge withdraw from a judgment when he is no longer in judgment seat and no longer in the court? It's a problem we have to consider. And what is the effect of that withdrawal on the surviving judges who are on the benches while he withdraws? Do judges have absolute freedom of speech? They can say anything they like, or there must be some restraint a code of conduct that binds them as some standards. That's a very important question. I'm straying a bit. So I think as far as judges appointed, there's a lot of propaganda. India is the only country where judges appoint judges. In fact, Justice Pandyan in the second judge's case went so far as to say that judges were always appointed judges right from 1919 Act, multi-term sole reforms, or at least from 1935 Act. And the Union Law Secretary filed an affidavit in the second judge's case, saying that out of 400 justices appointed, 394 or 395, I don't remember the exact number, but thereabout, were in fact approved by the Chief Justice of India. So the consultation always meant concurrence. The Attorney General argued in the second judge's case, he conceded that we give limited primacy. And that's what Justice Kerr says, who is the judgment? Who is the judgment? It's a big question, set apart. He is there, Justice Mbanaloku said. He analyzes the whole theory of the will of the people in the judge's case by saying there is always been the practice. Even though one member of parliament, Ram Jetpani, dissented, the rest of them accepted it, and analyzes Ram Jetpani's speech very eruditely, if I may say so. So it is always since the Constitution, judges, Chief Justice had got a major role in appointment of judges. Chief Justice becomes equalized. Where is the innovation, I ask? So I would appeal at least to younger people here. I can speak only about has-been people like me, authoritatively. They are sometimes weak here. But you should read the judgments. Afterwards, enormous judicial labor goes into writing of judgments. Enormous labor goes in the arguments to be made. And Justice Sikri's book is very useful in that regard. You must read judgments carefully. And if lawyers suppose read it for different reasons, I don't know if there's a chance so far in the bill reading fees. Really, I am so and so to so and so, and then could have the text was impact or something. I don't know whether they do it now still, but they used to do it before. Many testimony judges have reading fees. That means they've done the labor of reading a case. Why have they? They treat a case as a commodity, just as Sumit Malik does, and Surendra Malik did, from which a copyright is derived. So there are different ways of treating cases. Anyway, I don't want to go into that. I think Supreme Court has behaved responsibly and well in the application on development of basic structure. Justice Kerr said in his 500-page opinion in NJSC case, he said, and it is the most important statement made ever by any judge, said it's a bedrock of the Constitution, it has been said to be bedrock of judicial interpretation, but it is the idea of judges, appointing judges, or idea of basic structure, he called it a fragile bastion. That one has to be ever so careful and anxious. Judicial anxiety is not studied by law teachers and law students. I think Justice Sikri's book may be read as a statement of several judicial anxieties, the way in which judges become responsible and accountable to society. It's very important. But this is all foreplay, and I have no substance, in fact. Substance has been said by earlier speaker. All I would say is a festival of joy. I'm very happy to be here. And I cannot but, and it's a constitutional event in itself. Not just we are launching, we gathered here for a book that is published. It's a very great occasion for joy and celebration. But it's a greater occasion is the wisdom contained in the book marks this occasion a constitutional event. But I cannot help Justice Sikri remembering when I first met him. It was a law school in Lotika, Professor Lotika Sarkar's room. And Lotika had started a year ago or 2 years ago something called a Manu Sabha, discussion group of the active students. And he was the Sikh anchor of this group. I remember I met him as a young student of law, and ever since then I was seeing him occupying the highest judicial position. But it is inescapable for me today, not to remember Lotika would be a sacrilege. So I convey to you and carry to you her good wishes and her blessing from wherever she is on this occasion. And our choice of greetings are with you on this occasion. You would have been very, very happy that you have written this book. I also say a constant emphasis upon the title on was in the rule of law. And I would like to just remind you, I remember it only today myself. Have you heard of a man called Jawaharlal Nehru? Perhaps you might have. I'm not sure any longer. Young people know it doesn't appear on Twitter. I don't look at social media, so I don't know. But this is a great guy. And inaugurating, I think, the Afro-Asian Consultative Committee meeting, conference, on the subject of rule of law. He said the rule of law must run close, and I quote him, to the rule of life. And I've been teased by this statement. And I get a lot of insight from Justice Sikri's book on what the rule of law might be, what the system for judges is conferred. But I don't understand rule of life. Rule of life, was it the 9th Amendment, First Amendment, 9th Schedule? Was it cancellation, invalidation of Supreme Court judgments and constitutional amendment? Was unbridled parliamentary sovereignty? I don't know what he meant. But he had an important point that it should run concurrently, close to social life. And I think Justice Sikri brings this flavor of narrow insight into the rule of law, that it should not be only what Justice Sikri, I think, calls somewhere ivory tower values of the judge or of the court, but it must resonate with the people at large. In that sense, that was a profound insight, and I think this book carries that insight. I must end, but and after I make two remarks. One is, I wrote somewhere, and I've emphasized that in my epilogue or something, somewhere. He's the only judge, by the way, who has only justice, by the way. I can't think of anybody. If I'm wrong, correct me. Who acknowledges two teachers by the two chapters in the book. One is social empathy, and secondly somebody called, I forget whom it is. It is very interesting that he's done it. Because after all, it shows a great mark of humility, of a fellowship of learning. We all learn from each other constantly. And it's a very good thing. And therefore he learns also from previous judges, whether lawyers understand it, arguing counsel understood in a certain way, but he understands prior decisions in a very creative and concerned ways. And he cites Bachchan Singh, I think, in Justice Yashwant Chandachud. And that a wonderful quotation he cites. The last word I quote on justice, the question of justice and fairness, does not rest with the legislature. And a savage sentence, he says, is not contemplated. The criminal case. A savage sentence is not contemplated by the Constitution. I think this is a very important ingredient, it's integral part of the rule of law, that everything must be proportionate, and that if you combine this recall of Justice Chandrachud with his own passionate defense of proportionality, Justice Sikri's defense of proportionality, it's not a value of law, but social value, constitutional value, a value for desired social society, social order. It is, I call now that particular observation, and that several times it recurs, the theory of the last word. And that's what courts are meant for. When they dispute, it must not be quietus somewhere. And the quietus belongs not to legislature, not to exclusive but the court. And that is in the nature of interpretation. Now, I classify three kinds of courts in India. That is not the occasion. One is, I said in Andhra Pradesh, half the court was in the podium. And I was asked to speak on independence of judiciary. And I was tongue-tied, I could not speak, and I said to Justice Madhavi Goradia, the chairman of the Chief Justice of the High Court, I said, I'm tongue-tied because I know that half the people here, justices, have been blessed by Justice Sai Baba. Now, nothing against religion, but we are supposed to be a constitution of all religions. Anyway, I classified the Lokata, nothing against, I respect him, I respect all religions. I said we were Kacheri, there's an Adalat, we have Lok Adalat, to which the question of independence of judiciary matter. But we have something called Parlok Adalat. For Parlok Adalat, independence of judiciary makes no sense. So I think we have to be very careful that the Supreme Court, the High Court, and other courts do not become eventually that third kind of courts in India. That might be a good thing for the believers, but it's not a very good thing for all kinds of people that abide in India. So I think I must now end with the all of things, to say, well, end by saying, by making a personal request, Justice Sikri. And let wise and reflexive works follow from your active scholarly pen. As I've said, my beloved, I can only greet back Justice Sikri as Professor Arvind Datar. That's my, I guess I truly know little honor. And I think you combine with you both experience and insight, and creativity and discipline as a judge, and have a lot to offer to bench and bar. Therefore, I think you should write, above all, an autobiography. And judicial restraint should not be a virtue. When you write autobiography, you should please tell us and other next generation after that, about things you've not spoken about. For example, your own role in the background role in the if I may so-called judicial revolt of 2017. I think we should know what did you do in your curial capacity. What I distinguish between organizational and adjudicatory leadership, OAL. I was somewhere, I don't know where, Cambridge Press to publish it, and hermeneutical judicial leadership, HAL. So I would like to know a little bit from all justices about the organizational role they played, administrative role they played, or a role of peacemaker they played. For example, at the time of the courts during the Janata Dal time, to split down the harm between Janata justices, so-called Janata Dal justices, and the Congress justices. We all remember that. In Justice Chandrachud's time, Chief Justice Chandrachud's time, I was a personal witness, organized witness to this vertical split down the middle. We do not know, we as people of India, we as citizens of India, do not know what goes on in the court. And there must be ways without displeasing your colleagues. And you are quite diplomat yourself, if I may say so. Maybe you are an ideal author of a biography, and let people know what you think happened in your time to the judiciary. And that we never know, and I think it would be invaluable if you were to listen to this sometime in your writing. Thank you indeed.
Thank you for the wonderful address, Professor Baxi. And now it's time for the most awaited moment of the day. I would like to request Justice Kaul to please release the book, and I would also like to request all the dignitaries on the dais to open the packages in front of them and hold the book up in their hands. Thank you, everyone. It was truly a remarkable moment to witness. It is now time for us to hear from the author himself. Justice Sikri, please address the audience.
Let me, at the outset, say that I am grateful to all those sitting on the dais who have really made this occasion very memorable for me and my family. And I'm also beholden to each and every person who has come and graced this occasion. I find my colleagues at the bar, many advocates here. I find my colleagues on the bench, many sitting judges and retired judges, both from the Supreme Court as well as High Court. And it's not only Delhi High Court. I have presence from Punjab and Haryana High Court. I have presence, of course, they're sitting on even retired judges. And there are many professors who have come and graced this occasion. So I am, apart from my family members, so therefore I really extend my gratitude to all of you. My role was simple and straightforward today. That was to introduce the theme of the book. But I feel that it has already been done by all these esteemed speakers. Let me only share some of the thoughts. Actually, it was in the year 2018 when, as on this November 26th November, every year we celebrate Constitution Day. And it was 67th Constitution Day which was to be celebrated. And I was asked by the Chief Justice to, all of us and many others were asked to write an essay, contribute so that it is made a part of the book that was to be released on that occasion. And at that time, I was just reading some article where a great political thinker and historian had said that the average life of a constitution, he had studied, he had quoted from some study by some university, that many constitutions have been written in various jurisdictions, and the average life is only 19 years. That if we take the average of all, the constitutions have not survived more than 19 years. So the thought came to my mind that, okay, this is our 67th year. So what is the reason? And I therefore deliberated on that and wrote The Endurance of Indian Constitution, an article on that. Thereafter, we come to COVID. Mr. Lalit Bhasin was now writing a book on the 70 years of the Constitution. And he asked me to again contribute an essay for that book. And this time, I thought of constitutionalism, on that, or Indian constitutionalism, and we have to write something. COVID, and particularly lockdown period, gave me abundance of time which was available at my disposal, and I had read a lot about this. Whatever is the literature in various other countries, how the democracies have survived or thrived, or how democracies have even died in various nations. And then I wrote that, again in the context of Indian Constitution, and I came to know, I would say it's not my naturally original idea, that there is something, constitutionalism, which is above the Constitution. Justice Kaul has dealt with that in detail. And I started from the beginning. Maybe, as Professor Baxi has said, that I am a professor judge, so that maybe instinct was there. And so starting from how the democracies came into existence and how democracies are governed, it is not necessary that there has to be a written constitution. As we know, England doesn't have. But then coming to constitutionalism and governance by the elected people. As we know, our constitution, it starts with we the people. That means that it is we the people of this nation who have constituted this republic. And most democracies recognize that it is the will of the people. And going by that, the social contract theory, which was propounded by Thomas Hobbes, and how it developed over a period of time. So my hypothesis with which I started was that, look, when the people elect the government and majority rules, that doesn't mean that after we elect our representatives and we give them right to rule us, it doesn't mean that they enjoy now, after these elections, unwielded power. It is the Constitution, and our Constitution is a burning example of that, which limits the powers of all the organs of the state, be it legislature, which is the elected body, or be it executive, or even the judiciary. In the context of democracy, majority rule may be what we call a formal democracy. But when we talk of substantive democracy, then there are certain precepts, there are certain other values which have to be there. And these include respecting human rights, such as freedom of speech, the right to equality, and the right to life and liberty, ensuring certain rights to ethnic and other minorities, and adhering to the principles of democracy, thereby giving voice to opposition as well. And when we have these precepts in a constitution, we are in the era of constitutionalism, or we say that this is not only a formal constitution, but there are the elements of constitutionalism in that. Interesting thing is that on the one hand, or rather I would say the hypothesis goes further, that look, it is we the people, if we have elected the government, that doesn't mean that we have ceded our human rights or basic rights, which are based on dignity of human being. At the same time, in today's world and in modern democracies, we talk of welfare state as well. So on the one hand, it's a limited government which is governed by rule of law, which is governed by the principle separation of powers, etc., which are enshrined in the Constitution. And on the other hand, it is also a responsibility cast on the elected representative to work for the benefit and for the welfare of the society. First part, which the jurists call it a negative constitutionalism of limited government, and second part is positive constitutionalism. And if you see, I found that first part, that is our chapter on fundamental rights, and the second part is chapter on the directive principles of state policy article. And on that basis, I thought that we develop. I had written many essays on different aspects, but then this, as I said, this idea conceived that there could be, all these can be assimilated and a book can be written on that. And let me tell you frankly, and I should acknowledge, apart from my professors, other well-wishers, and two persons who were after, and publishers of course, were after me, and I don't find him here today, Mr. Lokendra Manik or Dr. Lokendra Malik, who was after me that you must write on this. He came one day along with Balram, who is my law clerk now, sitting here. He was in the final year of law. They virtually snatched all those papers from me and they said that we'll collate all this. And the in writing this book, the kind of I would say contribution which is given by Balram is tremendous. So I won't say much on that because the panelists are going to talk about this, and I would only say this much, that in this whole process I have said in the book what is the role of the court, on which my earlier speakers have deliberated upon. And again, yes, as was rightly mentioned, drawing from what President Justice Arvind Datar has said, that the two fundamental roles of a judge in a democracy, one is to protect the constitution and the rule of law, and number two is to bridge the gap between the law and the society. So first role in our constitution, again, we can see in chapter 3, fundamental rights, and second role in directive principles of state policy. So on that, panelists are going to discuss. I would not say more, except this, that again, at the end, you will find in the book that apart from these essays on constitutionalism and about access to justice as well, I have at the end written about my two teachers as well. One is Professor Baxi and other is Professor M.P. Singh, who is sitting here. because I feel that the qualities of a good lawyer, first good student, then good lawyer, and then good judge, which we acquire over a period of time, the seeds were sown in law faculty by my teachers. And therefore, I have still tried to weave it, these chapters also in the theme of the book, if you go through the book. And these are not out of place, but at the same time, it was my duty to mention that as well. Last comment, Professor Baxi, you were saying about our first meeting in Dr. Latika Sarkar's. I remember those were the days, and why I am saying so. This was reverse of ADL Jabalpur in law faculty which I witnessed. Professor Latika Sarkar was our professor in charge. And if you remember, those who were students in law at that time, because of emergency, there were no elections, students' election. Instead, there used to be a committee constituted where persons would be nominated, they would run the student union. And who would, in each college, would be the person, convener we used to call, convener, co-convener, instead of president and vice president. From top command to every college, this would come that this is our list and you nominate them. Professor Latika Sarkar said, sorry, I'm not going to accept what you are saying. I'll have my own person, and she has chosen me. And in that context, we were there in that room, and she described about me to you. Of course, thereafter, I remember when I became the member of the academic council, and you as professor were also member, as dean, and 2-3 times in the evening from law fac, when I would go to university vice-chancellor's office there to attend the meeting, where you would give me a ride. And from in your car, you took me, you said, oh, you are also going there for meeting. Come with me, I'll take you there. So, and only last thing, Professor Baxi has not taught me, but taught me in the sense that he was not my teacher in a formal sense. But in jurisprudence class, when many students used to ask her outside that of other sections, that you know what is the difference between law, A law and B law? We would be surprised, what is this all about? So then what are you studying? Are you studying jurisprudence? If you don't know what is A law, what is B law, go and attend classes of Professor Baxi. And we would go, even not in that section, and would attend those classes, where we were told the distinction between law, A law, and B law. Thank you very much.
Thank you, sir, for such a wonderful introduction to the book. We will now proceed to the next session of today's event, which is the panel discussion on the book's theme. But first, I would like to thank our respected chief guest and guests of honor for being a part of this momentous occasion. I would like to request you all to please join our audience for the panel discussion, and I would like to request our panelists to join Justice Khanna and Justice Sikri on the dais.
and make one. Link thing. So we also did correct.
ऐसा पूछना क्या है मैडम जी बस
I would request you all to please be seated and we will begin with the panel discussion in a moment. Please allow me to introduce our esteemed panelists to all of you. When it comes to finding a lawyer with a foresight and exceptional planning skills, Mr. Arvind Datar is undoubtedly one of the best choices. With 40 years of practice, Mr. Datar has represented clients in some of the most complex and high-profile cases in the country, establishing himself as an expert in tax law, company law, and constitutional law. He is also an esteemed member of the editorial board of SEC. Mr. Datar's contributions to the field of law are numerous, and his humility and meticulous planning have earned him the respect of his peers and clients alike. It is an honor to have you here with us, sir. I would like to request Ms. Priti Kumar, editor, to felicitate Mr. Datar.
May I suggest that we can save some time and do other felicitations later, because as you can see, I would suggest I'll just move into the moderation and start the session. It'll help everybody, I suppose.
Please allow us to go ahead with the felicitation.
Thank you. I'm so sorry.
Just the felicitation at least, please.
Right.
I would like to request Ms. Apurva Goyal to felicitate Ms. Madhavi Divan. I would now like to request Ms. Shoptaparni, our storyboarder at EBC Learning, to felicitate Ms. Professor Raj Kumar, who is the moderator for today's panel discussion. The stage is all yours, sir.
Thank you very much. It has been a fascinating launch, and I want to first of all congratulate Honorable Justice Sikri for really taking out time from the life of a judge to be able to write a book, some of which has been part of his previous writings, but to culminate that book into a fantastic tour de force on issues surrounding constitutionalism, rule of law, democracy, and of course also to connect that entire story as a part of a wider theatre of democracy is truly fascinating. Congratulations to you, sir. I'm going to skip my own introduction to the book because we are clearly running short of time. I have a fantastic group of 3 individuals who will be reflecting on certain pointed issues that I intend to ask them. We have with us Honorable Justice Sanjiv Khanna, Judge of the Supreme Court of India, Mr. Arvind Datar, Senior Advocate, Supreme Court of India, and of course Ms. Madhavi Divan, who is another Senior Advocate, Supreme Court of India. My first question to you, sir, Honorable Justice Khanna. It's kind of one of the things that the book has attempted to do is essentially to articulate the role of a judge in a constitutional democracy. The running theme in those 22 essays that Justice Sikri has written is that what is the role of judge in a constitutional democracy? And also equally important is that how that role has been to contribute to the transformation of constitutional jurisdiction, and in that process impacting the rule of law, which is a constant theme running through the book. In your experience, both as a judge and before as a lawyer, can you reflect on that theme?
Good evening. If one goes through the book, as far as the role of the judge is concerned, short sentence, it has been observed to uphold the constitution and the rule of law. And secondly, to bridge the gap between the law and the society. One of the other themes which I found in the book, which is of good, I felt was fairly interesting, was the change in definition, or slight change in nuanced definition of what is democracy. The book observed it's founded on two pillars. The first pillar is popular sovereignty, which is exercised by frequent and free elections in which people choose their representatives who govern. But the second part, which is more important, is the rule of values, which Justice Sikri referred to. In the book it is mentioned rule of values will mean separation of powers, rule of law, judicial independence, human rights, fundamental principles that represent judicial values such as morality and justice, societal purposes such as public peace and security, and so forth. These two pillars actually form the part of the rule of law, and that's how most of the judges function, should function, and we are supposed to function. The other thing which I found of some interest in the book was the observations, and I'd like to read them. Decision makers are influenced by assumptions and expectations about gender, ethnicity, class, sexuality, and other characteristics. Despite the judicial system's professed impartiality in terms of rule and decision-making process, experience shapes ideas and perceptions may have major difficult-to-see influence on judges' interpretation and implementation of laws. This is something which I have noticed and often try to check myself in the decision-making process, because invariably our likes and dislikes determine the beliefs about the work, and they get reflected in our judgments. Dominance of conclusion over arguments is something which we must reflect upon and check. Sometimes if the emotions get very high, it becomes very difficult. The third aspect in the book which I found was quite fascinating was the yardsticks to determine whether a judge is an activist or a restraint, exercises undue judicial restraint. One thing I just want to, I feel is probably the difference which we normally derive between judicial activism and judicial restraint probably requires a little correction. I'll rather divide it into three parts: judicious approach, passivism, and overreach. In the book itself, different yardsticks have been prescribed that I skipped for paucity of time, including one laid down by Bharat. In quite detail it's been examined, but I'll just skip to what Justice Sikri had nuanced as to the difference between the three approaches. He says, in the first instance, activism and self-restraint are relevant only when registration exists. Namely, a particular case falls in the zone which the judge has discretion to choose different courses of action. However, his discretion should not mean that a judge can impose his personal opinions on the society. The second is his reference to what is called the pragmatic approach to a particular issue, but at that time confining within the boundaries of law. Here the distinction is made between judicial activism and judicial restraint. The third one which he has derived is linked with a particular society, that these two concepts, or rather three concepts, are linked to the particular society and the legal culture in which we operate. I like to add to this the subject matter involved and the times we are passing through. Sometimes the subject matter involved is such that we have to restrain ourselves or show activism. So these are the three things as far as the role of judges, which I found quite fascinating in the book. They made me think about our functioning in the courts and role of judges.
Thank you, Justice Khanna, for really picking up some of those important points which Justice Sikri has articulated. Let me move to Mr. Datar. As a long-time member of the bar, you have seen the evolution of the courts and, of course, the judiciary itself. Can you reflect about some of the new challenges that the courts are facing today, especially with regard to that transformative constitution that Justice Sikri constantly talks about in the book itself? In some ways, the real question that I want to ask you is that, to what extent this evolution of the constitution and the principles of interpretation is going to be fulfilling the social expectations generated out of the courts?
Yeah. Yeah. First of all, before I start, let me congratulate Justice Sikri on a wonderful book. I'll tell the audience I've read the book, and it contains perhaps the best discussion on proportionality that I've read anywhere. It's a masterly discussion, and what I found most impressive was the number of footnotes, which shows a lot of scholarship has gone into it. And apart from proportionality, I tell the audience, please read the chapter on dignity jurisprudence. It's really touching and moving, where you have dealt with so many aspects of how dignity is an essential part. Now, coming to the question, yes, in fact, I joined the bar in 1980. It was just after the emergency, we had the elections and so on. When I entered the law college, there was emergency. When I left, there was no emergency. And what is the biggest explosion I've seen is the huge explosion of writ jurisdiction. When I joined the bar, there were hardly only one writ court, and writ appeals were part of the first appeal bench. The writ jurisdiction was completely a huge explosion. And apart from due process, we had PIL system came into a very big operation. We had a lot of issues on human rights, and the Supreme Court gave the lead that jail is the rule, jail is the exception, and bail is the rule, and so on and so forth. And over the years, I find that what is happening now is that increasingly society is expecting courts to be the vanguard of change. And as Justice Kaul pointed out, that's not always very possible, not perhaps advisable. But for the common man, he says that, yes, I've got a problem, let me file a PIL. And then that is where the courts have to do a balancing act, whether they can give the help or cannot give the help. Of course, the important changes have been made by the judiciary, for example. Recently, the Madras High Court gave a landmark ruling that a homemaker who stayed at home and who has worked, and while the husband was in Saudi Arabia and earned all the money, he said that that lady, she has contributed to the family and she's entitled to half the property. So this was a very important change, which is not there in any law, but has been created by the law. So there's been a huge thing, and I think that basic judges do respond to what Justice Holmes called the hydraulic pressure of social change. So there's been a great thing. And one thing I'll mention, from the time I joined the bar now, one very important and welcome change is the large number of women judges in the Madras High Court, and Justice Kaul is partly responsible, and the large number of lady advocates who are coming. When I was in the law college, there was hardly any ladies students, but now I find many women lawyers are doing extremely well, and that's an extremely important improvement that I've seen. Thank you.
Thank you, Mr. Datar, for that. I think I entirely second about the last bit of what you've said. At the other end of the spectrum, I can say that 50% of our law students are women, and clearly that is that I expect them to be part of the legal profession. Over to you now, Madhavi Divan. I want to ask you about the question, something that is very much dear to Justice Sikri, about the entire framework of how judges are essentially prepared to deal with complex issues surrounding law and economics and law and policy. Because one of the things that has a direct bearing on the adjudicatory process, especially in the future, is these new issues that are going to come to the forefront for the judges to decide, are we having enough training and capacity building mechanisms and methods so that judges are able to go beyond their comfort zone when it comes to only using their legal and constitutional knowledge, but also to look at other areas. In fact, one of the remarkable things he's done in the book is to look at issues surrounding law and literature and law and economics, both of which are chapters, essays in the book. So over to you to reflect on that.
So the role of a judge, as I see it, is really in the context of constitutionalism, is to serve as a bridge between the constitution and the citizens for whom the constitution exists. And in that process, a judge really breathes life into the constitution, the document, and that requires bringing context into the text. So that process, of course, the context, as we know, will keep changing. There are certain foundational values which will remain the same, but the context does keep evolving, and of course, judges lawyers also need to keep pace with, changing social realities, commercial realities, and a whole range of disciplines. Now, the law as we know it is multidisciplinary. It does not exist in a silos. And actually, this is something which lawyers ourselves, we need to remind ourselves, it's not good enough to just know the law. You need to have a much broader based understanding, and therefore it's a happy development that in this 5-year law courses we are offering liberal arts, because that is an important foundational education. But I think that yes, as you mentioned, Justice Sikri devotes a whole chapter to law and economics, and that's really, really important. In fact, I feel that Shiv Shakti Shugat is one of his very big contributions to that underlining that economic underpinning of the law. And to say, and what he really says is that, do we as judges do a economic cost analysis of orders, of judgments? Do we examine the economic impact of our judgments? And a cost analysis needs to be done. Now that can, have so many different, for instance, in say a competition case, where you have, say, an injunction passed or a status quo order passed insofar as an investigation is concerned. Now, are judges mindful of the economic? Sometimes that injunction may very well be warranted, but the question is one mindful of the economic cost of that status quo or injunction, which one might not, in practical terms also, it may not be, you may not even have the opportunity or the chance to really reverse it soon enough if it is warranted. So now, what is the economic cost of that to some unknown consumers who may not be before the court? In a competition case, typically it will be the end consumer who will be affected in ways that he probably doesn't even realize. But therefore, it is very, very important to assess the economic cost of an injunction or an order, or generally or the economic impact of judgments. When we also look at the Constitution itself, and not just the law, the Constitution is also in so many ways multidisciplinary. And it is therefore for a judge, I think the role of a judge is to really join those dots. Because if we look at our Constitution, what is it about? It's about, there's political science in it, there is history, there's philosophy, there's sociology, there is anthropology, identity, there is feminism, there's the environment, there's economics. So and there's a lot more. So, how does it, the challenge is to be able to join those dots. And if we, we've always been trained to look at the Constitution as an instrument of social transformation, which of course it is. But do we also do we overlook the economic underpinnings, the strong theme, which I see at least now, of economic well-being? For instance, if we look even at Part 3, Part 3 on fundamental rights, if you look, for instance, examine the right to equality, say in the context of women, and women, say, participation in the workforce, and that brings, say, economic prosperity to her, economic empowerment to her, independence to her, and that transforms her social status as well. So you know, how there is an economic underpinning to that. If you look at, say, equality in the context of caste discrimination, where somebody is compelled to do, say, what his forefathers did, practice that profession, what are we doing as a society? We are, of course, you know, you're killing, stifling choices, you're stifling talent and all of that. But what we are also doing is to encourage economic stagnation and economic inefficiency. So, you know, there is a strong, you know, economic, there's economics involved over there. If you look at the right to education, it's about economic opportunity. You look at the freedom of speech. When you stifle speech, it can stifle innovation, the marketplace of ideas, and innovation will translate ultimately into economic prosperity. So, yes, freebies also, yes. So freedom of association, you know, freedom of movement, all of that is about economics. So, I mean, are we looking at that, or are we just looking at these rights in a silos? Similarly, part 4 is equally, you know, on you know, distribution of resources and economics in so many ways, maternity benefits, equal pay for equal work. So all of this, you know, involves an understanding of various disciplines, and to be able to join the dots and see the larger picture, the role of the judge.
Thank you, Madhavi. That was fascinating. In fact, this is part of the running theme, not only of the book, but also many contributions of Justice Sikri. I also want to mention that he also talks about literature, and to what extent literature could shape the idea of law itself. Let me quickly move to Justice Khanna. This is kind of one of the things that that Sikri is very conscious of is the need to promote access to justice, and that's obviously a much larger theme. But what I would like you to focus a bit on is that for many of us who are looking the judiciary from outside, we constantly hear about the 5 crore cases pending, and to what extent the pendency affects the ability of you know, judiciary to fulfill the demands of justice. Now, of course, as an academic, I'm a little bit familiar with the nuanced reasoning that we need to have when it comes to understanding numbers. Can you throw us a little bit light on these numbers, but also to what extent judiciary is responding to the challenge of access to justice?
I mean, one area where we have done reasonably well is access to justice in terms of legal aid which we provide. As per the figures available, almost 30% of all criminal matters, legal aid is being provided at the trial court level, and the figure goes to 50% at the appellate level. I do not think anywhere in the world this figure can be matched. Almost 80% of the Indian population is eligible for free legal aid. In fact, most of the Western countries, it's very difficult to get legal aid at the appellate stage because they don't want taxpayers' money to be spent. The PIL also has broken down the traditional locus standi principle, and that's helped us deal with a lot of problems and issues, both in the High Court level and the Supreme Court level. Pendency is a big problem, it's an issue, but if one looks carefully at the figures, 5 crore figures, if one excludes almost 65% to 70% would be criminal matters, and many of them would be 138 and traffic challans. If we exclude those, what happens? Number 2, I think if one goes to the national data grid now gives us a breakup of the figures, and that shows that as far as civil matters at the district court is concerned, the disposal figure is 38% within 1 year. Then next year it's 15% cumulatively. It means within 2 years 54% cases are being disposed of. It goes up to 63% by 3 years, and 4 years is 73%. But what has to be done is, what we have to check out is, which are the cases which get long beyond 4 years. Unfortunately, that breakdown is not available. That has to be worked out. As far as the High Court is concerned, within 1 year, almost 40% cases get disposed of within 1 year of filing. About 59% cases get disposed of by within 2 years. Good figure goes to 70% by the end of 4 years. That's fairly good, but still, why should still we not be able to dispose of the other matters is something which we have to take into account, and probably every High Court will have to work on it, because it's not acceptable that the case takes 5 years or 6 years. We have been often talking about pendency. We have to also have figure of pendency, because pendency doesn't reflect the day the case is filed, it can become a pending case. We have to have breakup also with regard to the pendency figures. Until unless we have the backups, we will not be able to move forward and tackle this problem.
Thank you very much, Justice Khanna. I'm myself not familiar with some of these figures you said, so maybe there's a case for getting that numbers out. Mr. Datar, I want to come back to the access to justice question. One of the ways by which we can look at access to justice question is also about the enormous faith that the ordinary people of India have in relation to judiciary. They are, while everything else fails, they somehow believe that the judiciary is the last resort for their aspiration to seek justice. But the equally important aspect is that, is it always about executive failures that the judiciary is coming to remedy? Are there better ways to ensure that administrative mechanisms can be put in place so that coming to judiciary is, or it should really be about a last resort and not somebody else's failure is being dealt with judiciary?
Yes, what you're suggesting is an ideal, that if the administrative does what it's supposed to do, there'll be hardly any litigation. For example, just to give the example of Madras High Court, for example, 40 to 45,000 writs are filed in the Madras High Court every year, about 24 to 25,000 in Madurai. And 50% or 45 to 50% are just mandamus writs. Please consider my representation, grant me a patta, dispose my pension application. This is the point. Now, talking access to justice, well, people make a gloom and doom scenario, as Justice Khanna pointed out. If you go deep into the data, yes, there is arrears, there is backlog. But I look at it this way, that if 25,000 petitions are going to be disposed of and the citizens' basic problem is going to be solved, then it is a huge faith that the people have the access to justice. And I'll just give a small example of how it affects the common person. In the teacher recruitment exam, there were questions to be asked, and marks were given for the correct answer, and it had to be benchmarked against what the government said was the correct answer. One question was, who defeated Napoleon in the Battle of Waterloo? All of us knew it's a Duke of Wellington. But the government answer was they wrongly referred to some German scientist's name. So all those people who got the wrong marks, 12 people filed the writ petition in the Madurai bench. Writs were allowed, and out of the 12, 6 people got jobs in the government. So this is a common example, a very simple example, but a telling example of how access to justice. And now these people had nowhere to go. They can't file a civil suit. There is no tribunal. There is no other place. The only remedy is 226. So I think 226 has been the most important thing. The last words for any other purpose has been the fountainhead of access to justice for most people. And just to supplement what Justice Khanna said on arrears, I've been doing my own study on that. And the data given from the grid, in fact, the Supreme Court grid is very, very impressive and interesting. The arrears, if you find out, the High Court arrears, if you total the number of High Court arrears, 54% of the arrears are just in 5 High Courts. And if you go to the district judiciary, 53% of the arrears are only in 4 High Courts. And out of the 5 and 4, the most common are Allahabad, Bombay, Calcutta and Madras. These represent almost half the areas of the entire country. So maybe when we ultimately solve, I mean, we are discussing constitutionalism, but if we have to improve the access to justice, we'll have to focus on these problem states, and perhaps it's time to go into data analytics and then find out which are the main areas where it can be tweaked and the areas can be substantially reduced.
Thank you very much, Mr. Datar. That was very instructive. Over to you, Mr. Divan. You see, of course, we know that Justice Sikri is a member of the Singapore Commercial Court, and I want you to slightly talk a bit about the growth and evolution of alternative dispute resolution, especially in relation to mediation. The reason I mention this is that when I look around many parts of the world, increasingly commercial disputes courts are not the venues for adjudication relating to commercial disputes. There's a fascinating center called the Strauss Center for Dispute Resolution at Pepperdine University in the US. And I was recently there, and the kind of extraordinary invocation of non-judicial measures when it comes to not just commercial disputes is phenomenal. What's the hope for India there?
Well, there is a lot of hope, but I think, well, as far as arbitration is concerned, I think it's something that we should really be re-looking, because we haven't really tapped our potential. India, actually, we have, you know, the human resources are very much available. You have hundreds and hundreds of lawyers coming out of law colleges every single year, and these lawyers are going to need work. The work is available. You know, I found that a lot of public sector undertakings were going to foreign destinations. They were drawn to these, what I could describe as, you know, tourism, arbitration tourism hubs in, say, Singapore or London. Unfortunately, at great expense, when we could very well, if we were to provide that, you know, efficient, you know, alternative dispute system over here, which we haven't been able to. But I think there is great potential to be able to tap our human resources, create specialist bars with completely specialist and exclusive for whether for arbitration or for mediation, train them in law schools in collaboration with top law firms. This can very easily be done. It requires, however, a lot of determination, because this can be a real win-win situation for both lawyers and for litigants. And of course, mediation. I don't know how much we are really packaging mediation as, because it's not regarded as glamorous for young lawyers. So are we, you know, that needs to be done, whether law schools are really taking them up, because I think there is phenomenal potential.
Thank you, Madhavi. Well, we are coming to the end of this. So one last question, one question to all three of our distinguished panelists. I'm going to start with Justice Khanna. Justice Khanna, we are in 2047, we'll be celebrating our 100 years of independence. I would like you to do some blue sky thinking. What is your dream? How do you see the next over 2 decades shaping the future of legal system, but especially in relation to constitutionalism, rule of law, democracy? Same question to all three of you. First, Justice.
I wish this is very long. I think there are too many problems as of now. On the side of the citizens, I think better compliances. I think there is an issue. Discipline is lacking, self-discipline is lacking. Hopefully with the education and entitlement that you're part of the government or you're part of the whole system, society. On the part of the government, simple laws, less laws, humane laws. Perhaps enactment of law of mistake, accepting human beings are prone to mistakes, we made mistakes, and recognizes, at least in cases of bona fide or technical errors or mistakes made. On the part of the judiciary, shorter, smaller judgments, except perhaps in matters of some grave importance. The judgment should be written for the reader, that is in this case, most cases, the person who's a party. Not for intellectual satisfaction of a judge, when you can solve the problem much easier. Other things is gradually we'll have to assimilate information technology. We have done it in a big way. Artificial intelligence is going to come up in a big way. We have to harness that. On the part of the lawyers, less expensive, more friendly, litigant friendly, because courts are meant for that, and timelines and specialists in domain skills. Oratory skills should come down. I mean, we rely too much on oratory skills of the lawyers. The substance sometimes is lacking.
That's fantastic. Thank you so much.
Well, I've just got 3 points to make. One is, I think we have to focus on legal education. Unless the law schools turn out good quality lawyers, we're not going to have good lawyers, good judges in the years to come. Secondly, as far as courts are concerned, I've been trying my best to apply management principles to disposal of courts. We have only 11 judges per million or 15 judges per million. You don't have the resources to make it 30. So how do you double the productivity of a judge? So we did a study through the Balkyola Foundation of applying Kaizen and Japanese management principle to courts. And we did a survey of 7 criminal courts and 7 civil courts in Karnataka. And we found that in the time of a judge, because ultimately your most important resource is time. And the Japanese principle is muda is waste. Anything which is wasteful has to be eliminated. So anything which doesn't contribute to disposal of a case has to be removed. We found that 49% of the time of a civil judge in a civil court, trial court, is spent on calling work and adjourning cases. And in the criminal courts, in 7 courts in Karnataka, 53% of the time was just spent in calling the cases and adjourning the cases. Now, if we can outsource that into some kind of master system, we can really double or triple the productive judges. Just as AP Shah started the project, but then subsequently nobody took interest in that. So I was thinking we could apply principles. Justice Venkataramani told me that they'd applied the 6 Sigma concept in some courts in Birmingham. So perhaps we could think of applying management to courts. And lastly, I want to say, apart from courts, we have got the tribunal system. We have to easily create a tribunal, but no infrastructure is provided, nothing is provided. And a large number of cases can be disposed of by tribunals if you really strengthen that system. That really, that's a very, very big need to strengthen. A lot of the load of the courts will be taken away if you strengthen that system. Thank you.
Thank you so much. Please.
So 2 things really. One is, I think, more effective public engagement between the citizen and our court system. We've of course seen in the last several years how things have changed, essentially thanks to technology. There is now live streaming, there is transcription, there is, there are Twitter threads going out of courtrooms. There is all of this, and of course people are very interested in what's happening in the courts, but often they're not able to completely understand have a nuanced understanding of the court process. So I think as the legal fraternity also we need to participate in this, because what tends to happen very often is, of course, live streaming is also, there's a flip side to technology. Live streaming, for instance, it sometimes reduces it to, theatrics at a certain level. That should not happen. Your Twitter threads, for instance, where reportage takes place very often by lawyers themselves. I mean, it can really generate a very, very skewed, a superficial, a shallow understanding of the legal process. How do we check this? We can't, I mean, the genie is kind of out of the bottle now. You can't restrain technology anymore. But how do we promote a better understanding of the process? Because the public has a stake in understanding. This is linked, of course, with their ability to understand how the system works. Really, it will create that public confidence in the system, and that in itself has a link, with the rule of law. So how do we help that? And secondly is, I would say, just taking Justice Sikri's analogy to our system as a whole, I would say, are we going to have an economic cost analysis of the legal system and how it is able to deliver? Because we know now that our judges work, I think particularly of the higher courts, probably work harder than anywhere in the world. The kind of volumes that they deal with is just insurmountable, one. But at the same time, I mean, the bar also works very long hours, but somehow this is not translating into efficiency, and we perhaps need to do some audits and find some ways out where, say, people are not hanging around in courts for long hours, not knowing whether their cases are going to reach or not reach. I mean, the lawyers go away having charged a fee, but is that helping anyone? So a cost, an economic cost analysis even for that, and how we can improve that. Thank you.
Thank you so much, Madhavi, for those thoughts. For all those who are here, I must say that the book was absolutely a fantastic work by Justice Sikri. I also must say that the panelists worked very hard. We've had 2 sessions to prepare for this, so we couldn't cover all what we wanted. But I must thank all of them for their really candid and thoughtful reflections. My favorite 2 chapters remain what I would consider Justice Sikri being a judicial statesman, because almost 20 chapters talk about various aspects of law, but the fact that he paid tribute to 2 of his teachers and wrote an entire essay for each one of them at a time when the word gratitude is hardly expressed in the form and manifestation of sincerity. I truly applaud Justice Sikri for doing that. Thank you so much for recognizing it. And it shows a courage of conviction, but also character, which I think is important from the side where we are, as Mr. Datar said, we are part of legal education. He talked about legal education, he talked about legal profession. So those chapters which we didn't cover makes the book even more interesting than many other aspects of law as well. So I want to once again congratulate Justice Sikri. Thank you to all of you for being here, and thank you to Eastern Book Company. Sorry we took longer than what we intended to, but you are really committed people who are here, and thank you for your presence.
From my side, thanks all the panelists for doing a good dissection of my book. And I just wanted to thank Justice Mohit Shah, who has come all the way from Bombay or Ahmedabad. Thank you.
Thank you for that wonderful and crisp panel discussion. I would now like to request Ms. Ekta Kalra Sikri to the stage to deliver the vote of thanks.
Dignitaries on and off the dais, Honorable sitting and former judges of the Supreme Court, Honorable Chief Justice and judges of the Delhi High Court, senior advocates, colleagues, family and friends. It is my honor to be here in discharge of a delightful duty, and no duty is more urgent than that of returning thanks. Words alone may not do justice to express our deepest sense of gratitude to each one of you who's present here at this illustrious gathering. Alluding to what Martin Luther King said, and I quote, "Occasionally in life there are those moments of unutterable fulfillment which cannot be completely explained by those symbols called words. Their meaning can only be articulated by the inaudible language of the heart. I express the feelings which animate every person who hears me, and I only embody the sentiment naturally arising in the minds of all who sit in this august gathering, while being truly beholden to all of you whose words have enriched us today. We extend our profound and sincere gratitude to the Chief Guest of today's function, Justice Sanjay Kaul, for sharing such a rich experience with us and gracing the occasion today. A vanguard of constitutional values and rights, Justice Kaul's vision and words today bear testimony to the court's evolving a comprehensive rights-based jurisprudence and striking a balance with social action litigation. His enchanting words are a reflection of him resolutely guarding the core fundamental rights and augmenting their true meaning. Thank you, sir. You truly raised the bar and set the tone for the day. Our guest of honor today, Justice Sanjiv Khanna's commitment and devotion of judicial duty is boundless. Achieving justice in each case he takes up and decides is his prime motto. And deliberation as well as effort in each case he decides are driven with the same motto. Today, he has wonderfully described the true role of a judge in a democracy, and we can safely say that he himself possesses all these attributes in achieving access to justice. We're extremely grateful to Justice Khanna for agreeing to be a part of the panel discussion and enlightening us all. We could not think of today's function without the towering presence of Mr. Justice Rohinton Nariman, a jurist par excellence, a legendary human being, someone who's always enriched our lives with his wisdom and scholarly work spanning across numerous disciplines. Endowed with eidetic memory and astute intellect, his rich words today have immensely contributed to the ever-evolving concept of constitutionalism. His suggestion that a copy of the book be given to the people of Israel further encapsulates his version of constitutionalism. It comes as no surprise that Justice Nariman has also been invited to speak at the forum of Parliament of the World Religion, the same forum that catapulted Swami Vivekananda and Hindu religion to international fame, recognizing his humane approach and his innate sense of justice. Your words have always truly inspired us to strive for excellence. We're most grateful for your presence today. We're also extremely thankful to Mr. Venkataramani, a true jurist, patient yet assertive, a writer, a poet, and a teacher, for lending us his precious time and judicious words, particularly on the new theory of courts. Your words today especially how you link the various chapters to the central theme of the book are a true reflection of your scholarly wisdom and made this event a resounding success. The guru, the preacher, the emeritus professor of law, Padma Shri Professor Upendra Baxi, who's been a great academician and mentored the top legal minds of the country, including Justice Sikri, became a source of inspiration for the author and the added impetus to create the synergy for this book. Affectionately called the Bhishma Pitama of the academic world, Professor Baxi has not only illuminated the evening with his generous and kind words, but has also intrigued us with his wonderful anecdotes. We're indebted for your presence today, sir. We thank all our distinguished panelists, Justice Khanna, Mr. Arvind Datar, Ms. Madhavi Divan, and the eminent moderator, Professor C. Raj Kumar, who have all together contrived such a meaningful and thought-provoking discussion, bringing the book to life. Your insightful analysis, exchange of ideas, and bringing different perspectives to the fore have truly added fervor and flavor to the book. Noteworthy is the value addition to the book by Justice Chandrachud, Justice Nariman, and Professor Baxi, the Trinity, as the author likes to put it. The erudite foreword, insightful introduction, and the succinct afterwards, penned down by them, is remarkable. I profusely thank Chief Justice of India in absentia, Justice Nariman, and Professor Baxi in person. My endeavor today would not be complete without acknowledging the active support and tremendous help of Honorable Mr. Justice Satish Chandra Sharma, Chief Justice of the Delhi High Court, and in particular Justice Manmohan, Justice Shakdar, and Justice Bibu Bakru. Behind the scenes and tirelessly working is the entire team of Eastern Book Company, spearheaded by Mr. Surinder Malik and Mr. Sumit Malik, who have skillfully published the rich and authoritative work of Justice Sikri. It is rather imperative that I give a shout out to the entire team of EBC, among others Nilofer, Chitali, Bhumika, Prachi. Last but not the least, our deep sense of appreciation goes out to the entire team, administrative and IT team of the Delhi High Court, especially Mr. Grover, Mr. Pandey, Rohtas Singh, Anand. To borrow the words of the American professor H.E. Lecoq, no one can whistle a symphony, it takes a whole orchestra to play it. This event would not have been possible without their relentless effort in coordinating and the immaculate physical arrangement. I once again thank this esteemed gathering for making this a memorable event. Thank you.
Thank you, Ms. Sikri. I would like to take a moment to thank Mr. Ravinder Tuteja, Registrar General, Registrar Caretaking, and his team, particularly Mr. Rohtas Singh, Deputy Registrar, for smooth organization of today's event. With this, I would like to declare the end of this event. I request you all to please proceed to the lounge for high tea. I would request you all to please allow the dignitaries to reach the lounge area for the high tea and give them 5 minutes, please. Thank you so much, everyone.
Good.